what's your first sensation? What's your first perspective, your first view on this Van Buren versus United States case, on this interpretation of the CFAA?
Well, I think there was tremendous relief because the Van Buren, the facts surrounding Van Buren, not the facts about what Van Buren did with the computer system, but who he was and what the context was, made for a very unsympathetic defendant. I mean, one of the things about Aaron Swartz's case is that he was a very sympathetic victim of the CFAA. A lot of the times we've seen bad CFAA law advanced because the government and the private actors who invoke it choose their battles, and they like to pick on people who are uncharismatic and whose case is harder to make. But of course, once the precedent is set, then it can be wielded against everyone, not just the people who we wish would be curtailed in their behavior. In this case, Van Buren was a police officer who took a bribe to help someone who wanted to find out whether a sex worker whom he was involved with in some kind of nefarious scheme was actually an undercover police officer. And those are the kinds of facts that I think most of us recoil from and would be delighted to see the villain of that story held to account. And so it's hard to argue that we shouldn't distort a law to hold someone who has done something terrible responsible for their actions. And so when the decision came down that held that whatever else Mr. Van Buren or former Officer Van Buren was guilty of, he wasn't a hacker. And he hadn't violated a cybersecurity law, and that the cybersecurity law that they'd invoked, this 1986 law that Ronald Reagan rushed into law after watching the movie War Games and having a panic, and then letting a bunch of federal prosecutors whisper in his ear that there should be a statute against computer intrusion that was so broad that the government could use it just about against anyone. That law didn't and couldn't cover the specifics of what Van Buren was accused of, which was that he was accused of having a computer that he was allowed to access, but using it in ways that he'd been told not to. And this was equated to breaking into a computer that he wasn't allowed to access. And the court very wisely drew a distinction, although they also put in a footnote that said, we're not really drawing this distinction in the way you think we are. That has left everyone who's read that footnote going, well, then exactly what are you doing?